Hi guys, it's Kathy. I hope you're doing well. So, I found this case. It's a DUI case, and the guy wants to drive. So, we're going to watch this case unfold. It's flawless, it's perfect, it's unbelievable. Before we start this case, I left like a 3-minute clip in there beforehand so you can get a taste of this judge. And then like a few seconds of something funny afterwards. He doesn't play around. You'll see. So this DUI case is extra good. Now you can only see this here. It's Judge Ditton. I like him. So here we go.
The following, starting with count 1. Is it true that on or about April 5th, 2025, here in Elkhart County, state of Indiana, you did knowingly exert unauthorized control over the property of another person, to wit, merchandise of Walmart?
Yes.
And did you do so with the intent to deprive Walmart of the value or use of any part of said property?
I did not intentionally do it, but.
Well, the state actually doesn't have to prove that you intentionally committed the crime. The mens rea is called knowingly. But when you knowingly exerted unauthorized control over Walmart's property, did you have an intent to deprive Walmart of the value or use of their property? And you have to testify honestly. Don't say yes because you think I want you to say yes.
I didn't intend to, I didn't pay enough attention in self-scanning, which I don't use anymore.
So then what?
I was scanning and missed and did not realize I missed them.
So you're saying this is completely accidental? Is that right?
It was
okay.
Negligence on my part, but yes.
Then I'm sorry, I can't accept a guilty plea on that basis. I can't accept it. So I'm gonna have to return the plea agreement and I'll just set the case for trial. So let's see, there was no jury demand filed, so I'm going to schedule the case for a bench trial. Let's see.
Your Honor.
Yes.
And I changed that because I was told the one video that was seen was very accusatory.
Have you seen the video?
No.
Okay, I'm not comfortable with this then, I'm sorry. No, you need to, I don't know why you haven't seen the videos. Have the videos been provided? Yeah. Well, then you need to show them to her, please.
So I can't just plead guilty?
No.
And say I should.
No. I'm gonna schedule your case for a bench trial on Thursday, April 30th, 2026 at 8:30 in the morning, if that works for both sides. Yes, Your Honor. That's fine. Okay. Ma'am, we'll give this date to you in writing. Do you understand and acknowledge that your case is scheduled for a bench trial on Thursday, April 30th, 2026 at 8:30 in the morning? If you fail to appear for that trial, the trial can go forward in your absence. The court could convict you in your absence and a warrant could be issued for your arrest. Do you understand that? I can't hear you. Yes. Then I'll show the defendant acknowledges her bench trial in open court. I can schedule a pretrial conference before that date, and then perhaps we can resolve it at that date and you don't have to even go to trial. I'm not making you go to trial. How about a pretrial conference on Wednesday, April 1st, if that would work for both sides? Guys, we go like a week before that, if at all possible. No way. That's an interpreter day, and we're full. Your Honor, that works for the state then. And it's almost a whole month before the trial. Yes, sir. So April 1st work? That's fine. Gonna have to. Okay, and you need to be back here on Wednesday, April 1st, 2026 at 8:30 in the morning. I'm hopeful that you can review the videos before then. It's really none of my business, but it sounds like that would be beneficial. So I'll see you April 1st at 8:30. Criminal rule court time is not attributable to the defendant. Okay, I'll just see you then. Thank you. Have a good day. Is that a plea? Do you just, well, what's your case gonna be, the interpreter one, a plea?
It's a plea.
I don't know what your schedule's like, but, and that female hasn't even done her drug screen.
Oh, I have a time right now.
Okay.
I got the one done with.
He's got a plea coming. Okay, State State versus Tiffany Bolin, 20D042506 CM 1270. I'll take that, Mr. Galvan. Defendant appears with counsel Cody Galvan. Can you please raise your right hand to be sworn in? Do you swear or affirm any testimony you'll give today will be the truth?
Yes.
Thank you. State your name, please.
I'm Tiffany Yolanda.
What's your, you can put your hand down. What's your date of birth?
7/19/1980.
Can you still receive mail at,
Yes, sir.
okay, so address we have on file, your attorney has handed me a plea agreement. Do you want to plead guilty pursuant to this agreement?
Yes.
No problem. Before you can do that, I need to ask you a series of questions. Just let me know if I say anything you don't understand. Do you read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you have either a GED or a diploma?
No.
Do you feel that you have enough life experience, background, or wherewithal to go forward today with this
Yes.
case? Maybe you gotta let me finish.
Oh, I'm
I'm going
sorry.
as fast.
I'm sorry.
I can't go any faster. I
I'm
promise
sorry. You made me nervous. So
Well, I'm not trying to make anybody nervous, but that's not my intention. But you gotta let me finish my questions.
Okay.
Maybe, I mean, I could slow down in talking and maybe that would make people feel less nervous. I'll
No,
slow
you're
down.
fine, you're fine.
I just do, I'm programmed this way because my dockets are always so
No,
heavy.
I get it. I get it.
I will slow down.
No, you're fine.
Unfortunately, I don't even remember what I was asking you. Do you feel that you have enough life experience, background, and wherewithal to go forward today with this guilty plea and understand everything that we're doing without a GED or a diploma?
Yes.
The plea agreement and the advice.
So he did not, in fact, slow down. So we just saw him tell her no. Nope, I'm not taking your plea. Then he says, I'm not forcing you to go to trial. Well, you sort of are. But you don't get like a second chance of redo. Oh, I said the wrong thing. Let me try again. He made his decision, and that's what it is, period. But now we get to this guy. And here we go.
State of Indiana.
Kelly,
versus
thank you
Andrew
so
Langen,
much. Thank you.
20D042510 CM 1956. Defendant appears with counsel Cody Gallman. I'll take that now if you want. Could you please raise your right hand to be sworn in? Do you swear or affirm any testimony you'll give today will be the truth? I do. Thank you. You can have a seat. State your name, please.
Andrew Langen,
What's your date of birth?
11/28/1983.
Can you still receive mail?
Yes.
Okay, it's the address we have on file. Your attorney just handed me a plea agreement. You want to plead guilty to resolve your case today. Is that correct?
Yes.
Okay, no problem. Before you can do that, I need to ask you a series of questions. Just let me know if I say anything you don't understand. Do you read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you have either a GED or a diploma?
Yes.
All right, before this case here today, have you ever been convicted of operating while intoxicated in your entire lifetime anywhere?
No.
This is your first, okay. This plea agreement and then the advisement of rights and penalties form that was filed both appear to have your signature on the last page. Did you sign both documents?
I did.
Did you have enough time to read through and fully and thoroughly understand both documents before court today?
Yes.
Do you understand by pleading guilty, you are waiving your right to a trial?
Yes.
Do you understand by pleading guilty, you're waiving all of the rights contained in your plea agreement and advisement of rights and penalties form?
Yes.
Do you understand the charge and the possible penalties you're facing in this case?
Yes.
Your plea agreement calls for you to plead guilty as charged to operating while intoxicated as a Class A misdemeanor. To plead guilty, you have to admit to all of the material elements of the offense. So I ask you as follows. Is it true that on or about September 28th, 2025, you consumed alcohol to such an extent that you became intoxicated?
Yes.
And then on or about that date here in Elkhart County, state of Indiana, did you operate a vehicle while intoxicated on that alcohol?
Yes.
And you admit that the manner in which you operated that vehicle while intoxicated either did or could have endangered yourself or others?
Yes.
Does either attorney have any questions on a factual basis?
No, Your Honor. No, Your Honor.
Sir, have you had any alcoholic beverages today, or are you under the influence of any drug?
No, Your Honor.
Are you taking any medications that may interfere with your understanding of today's proceedings?
No.
Do you suffer from any mental or emotional disability that would interfere with your understanding of today's proceedings?
No.
Do you feel that you're thinking clearly and understanding what we're doing today?
Yes.
Have you been forced, threatened, or coerced into pleading guilty?
No.
Is the guilty plea that you're making your own free and voluntary act and decision?
Yes.
Going to the terms of the plea agreement, the sentence to which you've agreed is 1 year in the Elkhart County Jail, all suspended on 1 year of reporting probation. You'll obtain an addictions assessment and do any follow-up treatment. You'll attend a victim impact panel. The refusal suspension will be terminated. and you'll have a 60-day driver's license suspension imposed as a term of your sentence. And I'll hear arguments regarding whether the court will grant specialized driving privileges. You'll pay $100 fine plus court costs of $189.50 plus a statutory $200 alcohol countermeasure fee. Did I correctly go through the terms of your plea agreement?
Yes, Your Honor.
You initialed paragraph 20 of your plea agreement, which waives your right to appeal your sentence on the stipulated terms. In addition, you're agreeing to your sentence on the stipulated terms. Do you understand and acknowledge you're waiving your right to appeal your sentence with respect to the stipulated terms to a higher court?
Yes.
Have any promises been offered to you for your plea of guilty other than what's contained in your plea agreement?
No.
I do intend on accepting this agreement. If the court accepts the agreement, then the court becomes bound by it, just like you do and the state does. This is a binding stipulated contract and agreement you're entering into. You may never come back and have your sentence changed, modified, or reduced without the consent of the prosecuting attorney. Do you understand that?
Yes.
Does either attorney believe that there is a consecutive sentence here that I have to impose?
Your Honor. Very good.
All right. Do you understand that your conviction for operating while intoxicated will be sent to the Bureau of Motor Vehicles, where it'll become a permanent part of your driving record, and it'll count towards you becoming a habitual traffic violator and a habitual vehicular substance offender?
Yes.
Okay, now that I've explained all this, you still wish to go forward with the plea agreement, is that correct?
Yes.
Okay, I've already established a factual basis. I'll find the defendant understands the nature of the charge against him to which he has pled guilty. He understands the possible sentence thereunder. The plea was freely and voluntarily given. The plea is accurate, and there's a basis in fact for the defendant's offered plea of guilty. I don't have any reason to reject the plea if you want to go forward now.
Please.
That's all right with it. I'm only asking because the PC order says something about a crash and
I think he flipped his own vehicle over.
Oh, okay, but I can go forward.
Yes, Your Honor.
Okay. 'Cause I don't know anything about the facts and circumstances other than the PC affidavit, which is the state form that just has boxes checked. So I'm really in the dark here. Cause I'm gonna accept the plea, but what did you hit? I don't understand.
I don't believe I hit anything. Deer ran out in front of me and, I locked up the brakes. I was pulling a trailer
Oh.
and, the trailer brakes locked up and left the road and it flipped.
Well, your PBD shows a 0.18, so I'm sure that that significantly affected your ability to adequately react. I don't know.
I agree.
Okay, did you already read and understand the standard probation terms?
I did.
Okay, go ahead, Mr. Galvin.
Your Honor, we're just asking that you sentence in accordance with the plea's terms. Would you like to hear arguments for specialized driving privileges now?
Am I correct that you only have an ID card? Your record shows ID card only.
When I was in the jail, they took my driver's license.
I'm sorry, I don't mean to be rude and interrupt you. Let me back up. I'm looking at your BMV record and that license status is regular ID card. I'm not talking about did someone physically take your driver's license?
Right now I have an ID card.
You only have an ID card.
Correct.
And the suspension is only for 60 days. And so I don't want you driving around just on an ID card. And one of the newer things that I'm doing, this is particularly on people who I grant SDP for a long period of time, requiring them to get a driver's license within 60 days. This is only a 60-day suspension and he only has an ID card and there was a crash involved. So you don't even have a driver's license to drive on. I'm sorry, I'm not trying to short shrift your argument, but the odds are pretty low. I'm gonna do specialized driving privileges, but I'll listen to you.
Your Honor, should you grant SDP today, I'm certain Mr. Lang will head straight to the BMV. Will do so in very, very short order. He actually came prepared to make his pitch to the court himself today. Turn the floor over to Andrew.
Your Honor, I take responsibility for the offense. I understand why I'm here. And, I made it a priority to be accountable and to address the issues that brought me here. I've worked for the city of Elkhart for 14 years. During that time, I've never had a disciplinary action or write-up against me. My job requires me to drive a city-owned vehicle. If I'm unable to drive, I will.
Hold that thought. I can't do it anyway. I can't do it. There's even a statute, because even if I did this, I'd require ignition interlock. And you wouldn't be able to drive a city vehicle with ignition interlock.
Your Honor, not to put the cart before the horse. We'll show the court your, he's taking it upon himself to go ahead and get the
I
scram.
voluntarily got a scram bracelet.
Okay.
That's a show of good faith and my willingness to be held accountable.
And she'll go grant SCP today, everyone has to have the term.
Oh, okay, well, I didn't know that. That's now it's looking a little better for you.
My whole issue, Your Honor, is, my 14-year career with the city of Elkhart. I've worked hard to move up the chain, and, I've never had any problems there. And it would be devastating to me and my family to lose my position, which I will if I'm not allowed to drive.
Why do you only have an ID card?
So
That's what I'm really stuck on. I don't understand why you only have an ID
I'm
card.
a single father of 3 daughters, and my oldest daughter was getting her driver's license. They would not allow me to get her driver's license because I didn't have ID. So she got her driver's license on October 31st. So the workaround there was for me to get an ID card while I was there. And then I could use that as my ID for her to get her driver's license.
I don't understand why you don't have a driver's license. How
They
long
took-
have you not had a driver's license?
They took it from me at the jail when I was
I-
arrested.
I don't mean physically taking your driver's license. I'm talking about your credential status.
No, I have it. It's,
But you don't, because I have your record right in front of me and it says license type regular ID card. If you had a driver's license, it would say drivers.
I understand, Your Honor.
I
So,
don't understand. I need you to help me understand.
so when I was arrested, they took my driver's license, so I didn't physically have it anymore.
But that doesn't, that taking your driver's license physically from you does not change your credential status with the Bureau of Motor Vehicle.
Right. So, as I was saying with my daughter's driver's license, they said in order for me to get an ID, I would have to forfeit my driver's license, which I didn't have anyway.
Your Honor,
I'm
I can
sorry.
clarify, so I'm looking at the credential issuance on the DMV report for his license. It looks like the offense date was in September.
Right.
Looks like his driver's license expired on Halloween of 2025. And then when he went back in there, he probably just got the ID card reissued.
It did,
Oh, maybe that's it then.
I don't think it was expired. I think from what the BMV told me is you can only have one or the other. And I needed to get my daughter's driver's license. So I had to get the ID card. Cause they wouldn't give me a driver's license with the driver's suspension. I'm trying to say this the way I
Sure,
understand it.
no, I appreciate it. So are you saying that on the date you drove in this case, you
I did have a valid driver's
you
license.
had a driver's license when you were driving on September 28, 2025?
Yeah, you can see, I don't know if you have the ability to pull my driving record.
It's in front of me.
Okay, I wasn't very careful in my younger days, but since starting a family, I did a lot better. I haven't had, a ticket in probably 20 years, except for one stop sign violation a year ago.
Yeah, but now you got a drunk driver.
Yes, I know.
Okay. Anything else?
Just, I'm just humbly and respectfully asking the court to allow the scram bracelet as specialized driving privileges so I can return to work and provide for my family.
Through whom do you have scram? Is it Elkhart County Community Corrections? Is it Michiana Community Corrections? Is it somewhere else?
It's, total court services. Right now, it's voluntary, so it's not reporting to anybody, but it will be when it's, if it's approved and it goes through probation.
Your Honor, further for the court's consideration, we are only requesting driving privileges for the purposes of driving to and from work and within scope of employment. We're not even asking that he be permitted to drive to a gas station. I'll also note he's already completed the victim impact panel and he's 9 weeks into his 16 weeks of treatment.
That's helpful.
12 weeks.
What do you drive? What do you do for the city?
I'm a supervisor for, construction and horticulture divisions, of Buildings and Grounds Department. So my job is to drive, just a basic pickup truck, from site to site, only within the city limits, no CDL vehicles required. And just, you know, supervise my crews, make sure they're doing things right. I have employee verification letter here from my boss. It's dated 11/17 of last year. Cause that's when I went on, on leave. I haven't been to work since then because I can't work, because I can't drive. This letter is from my boss proving that I work for the city of Elkhart. I worked for 14 years and my position requires me to drive between the hours of 6 a.m. to 3:30 p.m.
And I'm just curious, there was no one else at your work you could just ride with?
They won't allow that because it's some technicality. I tried that, but HR wasn't having it.
Okay.
So the mayor himself offered me this, absence of leave to try to get this situation taken care of so I can come back to work.
You're in treatment now where?
New beginning.
Okay, state.
I was gonna object, but I think I've never seen someone come with scram, so.
I don't think I have either.
And that's very comprehensive. It's not, there's not the risk of, oh, he could drive someone else's car, so the state would just leave it to the court's discretion.
I don't have the facts in front of me. I only have that a measly PC affidavit. Is it correct that it wasn't a vehicle crashing into something or someone else? He damaged his own vehicle?
It was my vehicle.
Yes, it was a camper flipped on its side in the middle of the roadway. And he was standing next to the camper.
But there was no other vehicle involved or any damage to anything else?
Let me double check.
Did you damage anything else?
Not to my knowledge, no.
No, I don't even see a crash report for this.
Like I said, a deer ran in front of me. I'm sure my judgment was impaired. Once you lock up the brakes and there's a cable connecting the trailer to the truck, that breaks. The trailer brakes lock up forever, and then it left the road and flipped.
Now that I have all this additional information, it seems to me that you could get a driver's license very quickly.
I agree.
Is that correct?
Yes.
Okay. Well, I don't change my mind a lot, but you changed my mind. I mean, showing up with the scram and already being in treatment. Bravo.
Thank you.
I'm usually just like this. Okay, I read it and I gotta go. So you've changed my mind. I'll go ahead and I'll allow you to have specialized driving privileges. Of course, you gotta keep the scram.
Yes.
You know. I haven't had to go get a driver's license since I was 15 or 16. I don't know anymore how quickly that can be done. And I need you to get a driver's license. So I want to work with you and try to be reasonable. I'm not going to say you have to have a license in 7 days. I don't know if you can do it that fast, but I'm about to say 14 days, if that's enough time.
It is. It's my understanding from my recent trip there with my daughter that the BMV is not open on Wednesdays, but I could go tomorrow. I don't know what kind of documentation I'll need.
Well, what'll happen, I'll just tell you how I handle it. When I order this, I put your case on my work calendar on the day after whatever date I order, and I check your record. And if it says regular ID, I immediately terminate your specialized driving privileges. But I want to work with you in terms of, I'm going to order you to get an actual driver's license by a certain period of time.
Okay.
And I don't know how quickly or slowly that's going to take you. So I'm asking you.
I fully intend to attempt to get it tomorrow, and I will have, they mail it to you now. So, but I'll at least have paper printout of what they give you.
So do you think it's reasonable that you could get a driver's license if I ordered you to have it within 14 days of today? Now, I don't mean the physical license. I'm talking, because that could take time, but in your credential and your driving record would switch to drivers if they issue you a driver's license.
Your Honor, I believe that I can do that, but like I was saying, I don't know, based on the suspension and the vacation, I don't know what the process is there with the BMV.
Okay, here's what I'll do then in terms of the specialized driving privileges. Because it is gonna take a little time for the staff to get your sentencing order and we have to notify the BMV and all of that, but it won't take that long. In terms of the specialized driving privileges, I'll grant it. And then your attorney will need to file the proposed order, and it sounds like it's only for you to drive related to work, no place else. So you can't drive to the grocery store. It's only for 2 months. It's not that long.
Go ahead. If I may, could we make it so I could drive, I live in Granger, to drive to New Beginnings in Goshen on Wednesdays?
I'm okay with that.
Okay.
For treatment, okay, then treatment and work. And work-related travel.
Okay.
And you have to have the scram bracelet on.
Yep.
And so what I'll do, and I'm gonna make a note for myself, I'm gonna order that you must obtain a valid driver's license by February 19th. I just gave you an additional week. And what that means is, and I'm gonna do it right now, I'm putting your case on my work calendar on Friday, February 20th. And I'm pulling your driving record on February 20th. And if it says drivers, you're great. If it says regular ID card, I'm immediately issuing an order terminating your specialized driving privileges. Do you understand that?
Yes, Your Honor.
Okay. So you better get on it and get that driver's license by February 19th. Okay, did you already read and understand the standard probation terms?
Yes.
I'm showing that you were arrested on September 28th and bonded out the 29th, is that right?
Yes, Your Honor.
Okay, I'm gonna accept the plea agreement, find the defendant guilty under judgment of conviction. The sentence is 365 days in the Elkhart County Jail, all suspended. Defendant has credit for 2 days served, plus equal good time credit for a total of 4 days. So you're reporting probation, which does start today, is for the next 361 days. Also, the defendant acknowledges understanding his probation terms. You'll obtain an addictions assessment and do any follow-up treatment. Sounds like you're already in the process of that, and attend a victim impact panel. If you already completed that, then just prove that to probation. Your refusal suspension is terminated. There's a 60-day driver's license suspension imposed that starts today as a term of your sentence, but the court will authorize specialized driving privileges for the 60 days with the condition that you maintain the Scram alcohol monitor. And Mr. Galvan, make sure that that's in the order, please. And that you obtain an Indiana driver's license by February 19th, 2026. Failure to do so will result in the immediate termination of your specialized driving privileges by me on February 20th. You'll pay a $100 fine plus court costs of $189.50 plus a $200 alcohol countermeasure fee. There's a surety bond. I need to order that released. Can you afford to have your costs paid to the clerk by April 10th?
Yes, sir.
Okay, then that'll be your pay by date, and I won't withdraw you because you still have to file this SDP order. And you can only drive to and from the locations in the SDP order, which is gonna be your home, work-related travel, and your treatment provider. Do you have any questions?
No, Your Honor.
You know, this could have been a lot worse. You've been here all morning. Same thing with you. You flipped your truck or you know, whatever. You could have been seriously injured. Somebody could have plowed into your trailer. You've got to learn from this. I want to note one last thing. I mean, I'm assuming that you're not drinking because you're in treatment.
Correct.
I would hope so, because in your PC order, it says that you finished pretrial diversion in January 2025, and that case included account for public intoxication. So if you have a problem with alcohol, the treatment that you're getting, I hope it helps you to not consume it anymore.
Yes, sir.
Okay? Stay out of trouble and good luck to you.
Thank you.
One more thing, your license as of right now, your status, it is suspended because of the refusal. You can't drive right now.
Right.
We've got to get the sentencing order. I've got to get the SDP order. This all is going to take a little time. Right now, you can't drive.
I
So
understand.
be sure you check your status on the BMV website, okay? Good luck to you. Thank you.
Thank you.
And you gotta go visit with our probation department.
Okay,
So-
Right out here to the right.
The last two things at the end made that the most interesting. He refused. He refused the breathalyzer. And he also had a public intoxication in his past. But because he came so well prepared, he's already on a scram. He's already in treatment. He got a letter from the mayor saying, "Judge, please let this man drive." And it worked. So there you have it. If you need to drive for work after you received a DUI, this is how you get driving privileges. This was a flawless execution of him to get his driver's license. Is that crazy? Hey. It has been a while. Hi, CJ Love. Okay, now we're going to go. That was Judge Ditton. We're going to leave Judge Ditton. this guy. Saber, I think. This is another judge. Indiana.
Mr. Pelishek, 24 CR 3968.
Nope.
We're here for a sentencing hearing. Mr.
This is the chief judge of, I don't know what county they're in Colorado. You can only see her here. No one else plays her. I find her lenient, so I don't show her very often. She's very fair. She's very kind, and she's very lenient. So this case was out of her norm. Can't remember what county she's in Colorado, though. It's
Pelishek is here out of custody. Welcome, sir. I have Mr. Price and then Ms. Rickus for the people. And in preparation for today's sentencing hearing, I reviewed the statutory guidelines.
El Paso, Colorado.
I reviewed the complaint and report, as well as the original plea agreement. I reviewed the PSI in this case, and I also reviewed the acceptance to community corrections. I'm sorry. Got the wrong, hang on one second. Here it is. Yes, I also, it's the updated PSI that I was reviewing.
Do you happen to see my memorandum in aid?
And I read your memorandum in aid of sentencing. I read that in its entirety. So I am ready to go forward. I think I've reviewed all of the information that was provided. Ms. Rickus?
Yes, Your Honor. The people are asking for a sentence to the Embrace program, to the community corrections option, and the amount of 18 months. I would note that ultimately that requests come due to the fact that the defendant has received an opportunity on probation and very quickly squandered that opportunity. Probation notes a variety of concerns and says that the structure, as well as the treatment team, probation as well as the treatment team, note that the structure of community corrections would ultimately be a better situation for him, that they note a lot of different concerns as he went through the treatment opportunity he did have for the 4 months he was on probation before violating, that he'd make severely inappropriate comments during his treatment, comments such as teenage girls, which was the concern and the underlying facts in this case, that would get on the bus that he was driving are jailbait, that they are lot lizards, and that they are ultimately, what in probation's concern, potential victims that are ultimately in a situation where probation has asked him to stop doing this job, asked him to find a new job, and he's not done so, has not taken any steps to take himself out of that situation, clearly identified as being a concern for him. I would note that this, I think, contradicts defense's assertion in his argument that there's no indication that he's likely to reoffend, which also is directly contradicted by the initial PSIR that says in both sexual and violent recidivism that the defendant is at a high risk to reoffend. I'd also note probation had concerns with his compliance with probation, that the defendant refused ultimately to provide law enforcement or probation access to his vehicle when they came to search it, sitting down, refusing to go, that he also had weapons that were not, he was not allowed to have on probation. So really just overall not complying with probation. And there's no information or no reason that we see that anything's changed since the last time. I know he's been compliant for 2 months on probation, but ultimately, he had 4 months before that to comply and had many, many violations in that time frame. And so ultimately, I think that it's very clear that there's concerns that are going through this, as well as his treatment and amenability that's detailed by probation, is that in addition to all of the other concerns, he's not progressing in treatment. He's not following the rules. He's not learning the tools necessary to prevent him from acting out into the community. That's why they recommend the community correction sentence. So really what we see here is the structure needs to be placed because he's just simply not following the conditions of probation. There's no reason to think that that's going to change in the future.
Let me ask you a question. Would he be able to still receive VA treatment if he was in community corrections specific for veterans?
That I don't know. Don't know the answer to that.
The answer to that is no. I was wondering if you knew otherwise.
I do not.
Okay, does that concern you at all, given his veteran status and his trauma that may be unique to veterans?
I think that that is likely part of the reason why the offer was given initially. And so it is concerning, but also what I see here and him failing to take advantage of the initial opportunity he got is really more concerning. And so I think that it's unfortunate that we're having to choose between those options. But my concerns for community safety and the structure that he needs are stronger.
Okay, thanks, Ms. Rickus. Mr. Price?
Thank you, ma'am. So I respectfully disagree with the government's portrayal of my client. I will note that he does not have a prior record. I will note that this case was a sting, and the court may recall there is no victim in this case. The court may recall that my client was heavily intoxicated and there was a sort of a bait and switch situation, and ultimately he did take responsibility for it. I will note that he has no history of violence other than his service in Syria. I will note that even in this particular case, there was no violence. He did appear to freeze, and it unsettled probation, but he never threatened anyone, and he was never violent with anyone. And he ultimately was compliant. He is in continued VA treatment. In fact, he saw his VA psychologist yesterday in preparation for coping mechanisms for anxiety and being here in this courtroom today. And you can see he's doing very well. I will tell you that the nearly 45 days that he spent in CJC were informative for Mr. Pelishek. That is obviously the only major time. He only served 2 days initially in this case. And so the 43 days that he recently served before he was released in December was substantial. I will note that it was also it was highly informative for him in terms of his understanding of what he needs to do in order to remain compliant. And that is borne out by the last 2 months. Well, he's been completely compliant with probation while we've been waiting to come back here for sentencing. The other thing I will note is that if our concern is really for public safety, this is an F6. And 18 months of community correction with 1 year of parole minus his time served is a fairly short period of time. As you point out, the treatment will be significantly more limited. We have the opportunity to revoke and regrant and give him an opportunity of 5 years of SOISP, which we both know is an extremely intensive program. This will still be hanging out over Mr. Pelishek if he makes a mistake again. But revoking and regranting, I believe, has the best chance of not only rehabilitating Mr. Pelishek and giving him an opportunity to improve himself, but I also think it has the best chance of long-term public safety. A short stay in community corrections and a 1 year parole is not much. My experience with both community corrections and DOC is it takes a while to get people into treatment and approved for treatment, and that some treatment is simply not available, as you point out. Like he would have to discontinue his VA treatment. A more than 60-day incarceration sentence would terminate his benefits at least until he can reapply for them when he gets out. And so I think if our real concern here is, and let me point out, there is no need for punitive action here. There was no victim in the original case. Certainly, this 45-day CJC stay was informative for him, frightening for him. But I think it has done a real good in terms of informing him what the consequences could be and would be if he weren't successful at probation. I do think he will be able to be successful this next time. He was successful in the Army at following orders, and I think that this is. I think that this second chance is an excellent opportunity, not just for Mr. Pelishek, although certainly for Mr. Pelishek, but I also think that a 5-year SOISP treatment along with his VA treatment has the best chance of successfully avoiding further contacts with criminal justice rather than a short stay with community corrections.
Mm-hmm. What is the treatment that he would be receiving at the VA that he's not receiving now?
So what he's receiving now is,
I mean, through probation or through ComCore.
So I don't know what mental health treatment ComCore will provide to him. I know they will try to get him into their sex offender treatment program, although short term, given how short his sentence would be. His mental health treatment through the VA, he's seeing a specialist in PTSD. That therapist does see him regularly, either once a week or once every other week. And they are working on coping mechanisms for fight or flight, which is part of what the concern was with probation. His tendency to freeze and not be responsive in danger, which does stem from his PTSD, which is combat related from Syria. As I said, he's never been violent, but it can be unsettling because he's not responsive. But he's working on that and doing a very good job with it. His psychologist at the VA does indicate that he's doing well. The court may recall he did inpatient treatment with the VA as well early on during this process. They had placed him for 30 days. Was it 30 days or was it more? It was 60 days. That's right. Of inpatient behavioral and mental health treatment with the VA, which he completed successfully. And so the VA is keeping a close eye on him. And so and if the court does not have that record, I may have that certificate in my file, which I could provide, but I think we may have given it to the court early on in this process. So he is receiving fairly comprehensive VA treatment, both from a mental and a behavioral health statement. And certainly SOISP on top of that is quite a bit. And I will also note that the government did mention his job. He has not been working that job since he has been out off on probation since his last bond release.
Okay. The way you're describing Mr. Pelishek is his behavior that led to the original plea, which I'm very aware of. And then after that, as someone who is kind of passive and gentle and freezes up because of some sort of PTSD, that is definitely not the description that is included by the probation officer, where he was aggressive. He refused to respond to de-escalation commands. He balled up his fists. He refused to communicate. He had multiple knives and other fire starters, et cetera, that he's not allowed to have. And he had a laptop used to watch pornography and so on and so forth. It's a very different description of your client.
So, yes. And so, but I think it may be some lack of understanding on the part of probation as to his response. The freezing and balling of the fists and not being responsive are this fight or flight response, right? It's not aggressive or threatening, and he certainly didn't threaten, and he didn't hurt anyone or lunge at anyone, but this freezing up. But he is making significant progress with that from the VA. And Judge, I will tell you, I breach my own anonymity here in the courtroom. I'm 21 years sober. So have some familiarity with substance abuse disorders. Mr. Pelishek is a success story in that regard. So when we saw him very early on in this situation, he had a very severe substance abuse disorder, alcohol and benzodiazepines, which he was very dependent upon. And he's now almost 2 years, I think, sober, year and a half sober. From both substances. It is not unusual for people who struggle with substance abuses to engage in other compulsive behaviors even after they get sober. And the VA is also working with him on that. And he has taken responsibility for that laptop. He does understand that was inappropriate. There was nothing illegal on it, but it was not allowed. And so he knows that. And those types of compulsive...
Pornography is illegal because it's against my court orders.
Yeah, I understand, Your Honor. Yeah, that's true. And he did it, and he admitted to that as part of his admission. And I do think that there's nothing more to be said about that other than that is true, right? He did have that device. He did utilize that device in contravention of the court's order.
But he was sober on October 15th, when he was downright not listening to probation, refusing to comply. That's not a sobriety issue.
No, but what I would say is that one of the things that sometimes happens with PTSD in particular is that people find, and not just PTSD, a lot of different types of mental health disorders, is that people find a way to self-treat those disorders. So in Mr. Pelishek's case, it was alcohol and benzodiazepine that was treating these issues that he struggled with for a very long time, until he was able to get sober. And so this is
I guess maybe I'm just not stating this correctly. I really don't have any interest on what happened before my original sentencing. I was here for it.
Yeah.
I made the decisions. I considered everything that was presented to me at that time, and I read through everything with a fine-tooth comb. So I really know what was happening or what was allegedly happening with Mr. Pelishek. What I'm worried about is that I made orders and I sentenced you, sir, at that point, and you blew it off. Not only did you blow it off, you became a major problem for probation. And I'm wondering and you were sober at the time, according to what Mr. Price is saying. You had, treatment available to you. You didn't seem to care about that. Why should I give another chance? And that's what I'm going to be asking you. So I hope that you have something good to say in a moment. But I just noticed, are you here to talk on this case? And I'm sorry, I didn't even realize you were coming. So I apologize. I would have waited.
We get to hear from the probation officer. Don't worry, we hear her.
You weren't tardy. We started a little early and I should have waited for you. So I apologize. What would you like to tell me before I talk to Mr. Pelishek?
Well, in addition to my report that I wrote on the pre-sentence investigation report update that I submitted,
Which I've read, yeah.
is just I wanted to point out that Mr. Pelishek he does need treatment. He does need mental health treatment as well as to address his sexual addiction treatment. So the sex offense specific treatment. The problem is that his behavior during that home visit not only was threatening to me, but to 3 other officers. We had 4 out there on that day, which is significant. He seems to do really well because he was in the military in a structured environment. And so having him be able to be into ComCore, he can get a structured environment as well as the treatment that he appears to need and in order to be successful.
Here's my concerns that I wanted to ask you about, so I'm thrilled that you're here. I'm very concerned about what you wrote in your updated pre-sentence investigation report, and I'm worried about them. However, we have a veteran. We have somebody who is on his first revocation. We have someone with no criminal history. And we have somebody who needs mental health treatment plus veteran-specific treatment that he is only able to get through the VA. And ComCore doesn't offer comprehensive treatment like that, as far as I understand. And ComCore offers a very short sentence, which is a very short period of treatment, compared to what Mr. Price is advocating for, which is a 5-year SOISP on a revoke and regrant. Wouldn't a more comprehensive, longer period of treatment for his particular needs, which are veteran-specific needs, PTSD, et cetera, sex offense-specific treatment, and perhaps whatever else, substance abuse, continuing substance abuse treatment, that sort of thing, wouldn't a longer period of treatment and comprehensive treatment be more effective than just incarcerating him in a ComCore program with less treatment for a very short period of time? And it's 18 months and he would get his credit for time served, plus, he's going to be out in the community in no time. That's just the way it works. It'd be like a flash in the pan with very little treatment.
So according to the document that Community Corrections submitted, they said that he would be getting treatment through the VA for his veterans needs. And then he would also be getting the sex offense specific treatment in the community.
I don't think he can get that treatment, right, Mr. Price, because he loses his benefits.
So if he gets more than 60 days, my understanding is his benefits will be terminated until he reapplies after release.
So he won't be eligible for those.
While in Community Corrections,
Mhm.
so their document. I'm not 100% sure if they can get the VA coverage in the while he's in ComCore or not, but that's what their document says, that they would, refer him off to the VA for his continued treatment there.
Okay. And it would just be a short little stint. What's your thought on that? In terms of serving the needs of the community by actually providing comprehensive treatment for a longer period of time to actually have Mr. Pelishek get well.
So the concern that I guess probation has is that his behavior during that home visit, we don't get, guns, handcuffs or anything. We're going out there strictly with just some de-escalation skills. I have a few defensive skills that I can use. And then a couple of us have the ability to have pepper spray.
Mhm.
That's it. So if he becomes aggressive into this fight or flight, just his natural behavior, and he gets into that, the fear is going out and searching his house and having other devices on intensive supervised probation. So part of intensive supervised probation is me going out to the house and making sure that he's in compliance with everything.
Mhm.
And if those behaviors, if he can't change them,
Mhm.
stop them, my safety becomes in concern more than,
Mhm.
anything. And so, my original request was for a DOC sentence, but because of the treatment aspect, I was thinking it would be beneficial for him to be in community corrections where he could get treatment. I know both options are super short, where probation is a lot longer.
Mhm.
But his behavior on that home visit
Was so scary.
Exactly.
And is there anything, and this is just a question for you because I don't know how it works, but if you went out to a home visit and he started to display anything similar to that, I'm not coming with you, I'm not complying, could you just write a motion for a warrant, file a complaint report, and I can just send him to DOC or community corrections?
Yes, because one of his terms and conditions is to comply with the home visit. So yes.
How would you feel if I empowered you with that? I'm not going to make you go out there and continue to subject yourself to some terrible situation if he decides that he's just going to do the same thing. You just turn around, get in your car, drive away, and we'll send you to the community corrections. How would that be?
I would have to, I may be okay with it, but I also have to have a partner that's going to be okay.
Yeah.
To go out to that home visit
Mhm.
and be willing to make sure that he's doing everything correct on
Mhm.
intensive supervised probation.
Yeah. Okay. Thank you, Ms. Vigil. I don't want to minimize your concerns. I think they're valid and I worry about you. And so I also think a very short stint is going to put him back out there and a danger to everybody. And so I have to weigh those things and that's really difficult. So, okay, thank you. Mr. Pelishek, what do you have to say?
Thanks, Your Honor. Everything I've done, I've done it to myself. There's no one to blame but myself. From the beginning, substance abuse, enough was enough. I'd been working on my alcoholism for years, and I finally hit that. It's like, I don't ever want to drink again, and so that's done. We're not talking about alcohol here. I know you said that earlier. If, I thought about it earlier. It's like, if I can have that same mentality of enough of drinking, enough of non-compliant, fighting the system. Life's too good to be sitting in jail, just in and out, That's all you hear in jail is people, say, man, I wish I would have done it better. You're young, you have a chance, do it for me. It's like you hear all this wisdom and, it's only up for me to decide, what do I want to do with my life? Do I want to keep fighting, a lost cause? It doesn't do me any good. Hurts my family, hurts my, probation, hurts everyone, hurts my life. And, I want to, comply. Being in jail was, an eye-opening experience. It's not an experience I want to, have in life. I need to work on my, I have been working on my, fight or flight anxiety. It's not just psychologists, speaking and you understand, you have to comply, practice it, understand it, and it's no excuse. I don't want probation to feel like I'm a threat. I'm at fault. I was defensive, I knew I had a laptop in my car and, I was like, oh man, they never, just being stupid. But Your Honor, I'm a slow learner, but, once I get something down, it's like, okay, I got it, and I complied in the military. I was a good bus driver, had a lot of pride in my job. And, I know I can do things right in life, and trying to fight the system, it's a lost cause. It doesn't do any good, got to be on your knees, thanking God, for this opportunity to, be here in this world as a free man.
Okay. So I remember our original sentencing. I remember you said that you were ready to do all of this, but then you didn't. So why should I listen to you today?
That's a very good question, Your Honor. I often think the same thing. Why do I deserve to, be out and about? What am I going to do different? I know you've heard every single thing, but, honestly, is what I was saying earlier is like, beat alcoholism, I had enough of that behavior. I don't ever want to, drink again. And this whole fighting the system, just accept you have a problem, get help. There's no shame in that. We all have issues in life, and trying to hide things and, because you're ashamed, tell your parents or probation doesn't do any good. Now that we're out here, it's like, you got the help you need, go and do it. It's on you,
Do you agree that you need treatment?
I do agree, absolutely, 100%, Your Honor, that I need treatment. It'd be my very best interest.
Do you know you scared Miss Vigil?
Yes, I'm aware that I scared Miss Vigil, her partner, Brittany, and the rest of the team. My unpredictable nature, my nature of, joking and, not really know when I'm serious. And, like I told her later, she has a very dangerous job. You never know, what you're going to run into. Was it my intent to, be aggressive? No. But I guess it happened in the moment. And what, Joni said to me really stuck out. It's like, if you didn't realize you were, aggressive in the moment, then that's why, it's concerning, but I do admit to, being not kind of compliant in the moment, standing there kind of, thinking, oh, here we go, back to this. And, I guess, ball in the fist may have been a position of tension, but, I don't want probation to feel as if, I'm a danger to them, anything. Because, I value their life. I value my life. My life is too good to just spit out for anger and vengeance and hatred to go and do something to put someone's life in danger.
And I will note, Your Honor, he is working on that very specific tendency in fear with his psychologist at the VA.
Okay. Okay. Well, it's a hard one for me, Mr. Pelishek. And the reason that it's a difficult issue is because I feel a duty to protect Ms. Vigil and the officers of the court. They're just doing their jobs, and you weren't doing your job. And so that's hard for me. At the same time, I respect that you're a veteran, and I respect that many of our veterans like you have mental health issues and other issues that you need to work through, but your issues are really serious. And I'm hearing you say the words today that you know what you need to do, and you're ready to do that, and you value your life. And but those are words, and I need them to be actions. All right. I am going to go ahead and revoke and regrant your probation. And, I've hinted at that today, but what I'm getting at is that I think you need a longer period of treatment than you would get in community corrections. I also don't think you'll get the comprehensive treatment, according to Mr. Price, because I do agree that it's likely that you would lose your benefits and you wouldn't be able to have the VA treatment. And the VA treatment is going to be really important from a mental health perspective and particularly for a veteran like yourself, because they deal with specific issues that come to our soldiers from their service. So I think that you are young. How old are you? 29, right?
30, Your Honor.
30. Congratulations, you had a birthday. You're, by my estimation, by Mr. Price's, I'm sure you're young, okay? You have a whole life ahead of you. Just don't mess it up. That's something you can do consciously. So I am going to give you revoke and regrant your probation, and I'm going to make it a 5-year SOISP sentence. I'm going to put a very specific caveat in there. If probation or anyone else comes to check on you or wants to check on you, and you are even remotely aggressive or non-compliant, they have the right to file a CNR, and I will only consider community corrections or prison after that, because I'm going to protect them. And I'm giving you this chance, but it's got a tiny little leash when it comes to the people who I am empowering to try to help you. If you show you don't want to be helped, it's over. Does that make sense to you?
Yes, Your Honor.
I'm speaking in really frank terms because I want you to understand the next thing that's going to happen is incarceration. If you go one step out of line in showing that you are not going to comply with probation. Do you understand what I'm saying?
I understand, Your Honor.
Okay, because they can't be in fear because you have made a bad decision. Do you know what I'm saying?
Yes, Your Honor.
And it's not just Ms. Vigil, it's everyone who I am empowering to try to help you. All right? Ms. Vigil, what else can I do as a condition of probation to try to help make you feel better or safer?
Chocolate.
I don't think of anything else other than that.
Okay. But I do want to
Beers.
just stress that for you, Ms. Vigil. If there's any question, you let me know. You don't have to stay there. You go away, you call law enforcement, whatever you need to do, and I'll take care of it, okay? All right. So, Mr. Palachuk, on a positive note, this is giving you a whole new chance, your last chance. So make the most of it. I know you can do it. If you've been sober for that long, I know you can do it because that takes fortitude. Okay? All right.
So he went from 18 months to 5 years. Do veterans deserve leniency? Absolutely, 100,000%, yes. But when it comes to minor children, no. Nope, no. You can't explain that away. But the PTSD, you know, he's in treatment, you know what I mean? So he's getting the help that he needs. It doesn't look like it's working very well, but hopefully the VA, I mean, I know they used to be not the best at helping vets, but I think they're getting better at that, I think. Who knows? Hopefully they can figure it out for him. Not the minor children part, though. There was never a victim. So what happened was the police pretended to be an underage girl online, and this idiot fell for it. And then he's a school bus driver. Not anymore. He's not a school bus driver anymore. But I don't know if I would say I wouldn't use it as an excuse, Bobby. I wouldn't go that far. Mitigating factor, absolutely. You know, absolutely. You know, we don't think about what happens to these veterans and how it affects them. And they are there for us. Period. They deserve everything. Everything. You know, but I don't know. We have to get better with vets. We have to. So this doesn't happen to begin with. If he had proper mental health to begin with, while he was serving, after he was done serving, this might not have come to this. You know what I mean? All right, now I got to shrink this down. You are not going to believe it because it shouldn't happen. It shouldn't. This, I don't know how a judge allowed this to happen without jail 20 times over. But it did happen. Here we go, guys. I don't get it. I don't understand.
Brandon Hall's case, but if it's okay for Mr. Hall to maybe stay where he
may.
is right now.
Yes.
Thank you.
Let's go on the record in 26 CR 188, People versus Brandon Hall. Entries of appearance, please.
Rafe Taylor on behalf of the people.
Jeffrey Levick on behalf of Mr. Hall, who appears in custody. We can waive further reading and advisement of Rule 5, as well as the 3-count reading and advisement of the 3-count complaint and information. We do have a signed copy of the protection order. I'd ask to approach with that, and then if we can address bond, please.
Yes, please. Thank you. All right, good morning, Mr. Hall. Sir, I'm going to talk to you, sir. Mr. Hall, I'm going to talk to you about the terms of this mandatory protection order that will go into place in your case this morning. I'm holding this order
Coffee.
up now.
Be right back.
Is this your signature on the page?
Pay attention.
All right, this order will name you, Mr. Hall, as the restrained person. It will name Patrick Dougal as the protected person. The order does not involve a crime of domestic violence or a Victims' Rights Act offense, and the order will contain the following terms. First, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are accused of committing. Second, you will vacate the home of the victims and witnesses and stay away from any location they are likely to be found. And third, you will not contact or have direct or indirect communication with the victims or witnesses. Do you understand each of those terms, sir? Yes, sir. All right, please make sure you comply with this order while it's in place. If you fail to do so, you may be held in contempt of court or charged with a new crime, which could be a misdemeanor or a felony. Argument as to bond, please.
Yes. To start with, I'm not sure the complaint is actually making out the felony motor vehicle theft as filed, but I would just start by noting that while the legislature allows this, if the prosecution is making out felony motor vehicle theft, allows, based on the allegations of prior, for this to be charged as an F3, as the conduct is still the same as if it was an F5 motor vehicle theft. It is simply the inclusion of priors that changes the level. We'd ask that the court is setting a cash or surety bond to set it at the F5 level. That being said, we are asking the court to consider a personal recognizance bond here. Mr. Ho has been in Colorado for his entire life. He currently has been struggling with housing, but Mr. Ho does have a schizophrenia diagnosis. He is not currently medicated. While we're not ready at this point to make any definitive decisions about motions, I do think that is a real chance that could be part of the future of this case here. I think that's a situation that we know deteriorates while in custody, and that pretrial services with mental health screen and mental health services and support would better put Mr. Hall in a position to succeed. There is allegations of damage to the vehicle here, but not of any violence towards anyone else as well. Mr. Hall's family does live in Colorado as well. He should hopefully be able to stay with a member of his family. And given that, we are asking the court consider a PR bond.
All right, thank you. People's position, please.
Your Honor, the people are requesting a schedule setting for the defendant. I do believe that's $25,000 cash surety, largely due to the failure to appear history.
All right, I don't want you to hear it yet. I just want you to realize. I want you to realize one thing. The defense attorney, with his excellent accent, just asked for a PR bond. And I don't 100% remember if he gets it or not. I'm telling you this right now. I don't remember the outcome. I just remember the very next sentence that comes out of the prosecutor's mouth when he says no to the PR bond. No, abso-freaking-lutely not. And I'm positive the prosecution had said no to PR bonds many, many, many times before. And for some reason, with this guy, judges are not listening and granting. I don't know. Actually, I don't know that. I'll tell you why. He might not have had a lot of PR bonds. He might have had bonds. But wait till you hear the next sentence that the prosecutor says. He's saying no to a PR bond for his FTA history. He has a history of failure to appear, right? But listen.
The defendant, I believe, has failed to appear 40 times in calendar year 2025 alone. We have no.
How does he fail to appear 40 times in 2025? How? That means you put him in jail a long time ago. Which also makes the defense attorney asking for a PR bond that much more stupid. This man is not going to show up to court. I can say that with confidence. Did you want to know why? I can say that with absolute confidence. I'm 100% sure he's not going to show up if he bails out. Because he's done it 40 times just last year.
No faith the defendant would voluntarily appear for future court dates if allowed out on a personal recognizance bond. The defendant has numerous 6 pending matters facing him. Most of them are in warrant status for failing to appear. And the criminal history is somewhat extensive with over 25 convictions. For these reasons, we do not believe a personal recognizance bond appropriate and request this court set bond at schedule $25,000 cash surety.
All right, the court's considered statements of counsel. The court's own.
No, not $25,000 bond. No bond. Abso-freaking-lutely no bond. He is a flight risk.
File on the pretrial bond report. The top count charged in this case is first-degree motor vehicle theft, a Class 3 felony. It carries a guideline bond amount of $25,000 cash or surety. The bond report rates Mr. Hall at a -7, very high risk. It notes 6 pending matters at the moment. It notes a extensive criminal history going back approximately 10 years. Most of the convictions are, or at least the recent convictions, are lower level, but there are a number of felony convictions as well. Looks like a total of 5 felonies. Of greater concern is the failure to appear history. This is probably one of the worst I've ever seen. He averaged at least 3 failures to appear per month last year. So given the failure to appear history and the criminal history, the court will find that a guideline bond setting is appropriate. Bond will be set in the amount of $25,000 cash or surety. Conditions of bond will require no leaving the state without prior permission.
So he's going to give $2,500, not show up, and they're going to say, oh my God, he didn't show up for court after we told him to. I can't believe it.
Court and a waiver of extradition. The court will also order pretrial services with a mental health screen as a condition of bond. And we'll set this case. We have a complaint. Was there a waiver of formal reading and advisement as to the complaint as well?
Yes, there was.
All right, you want to go ahead and set for preliminary hearing?
Yes, if we can set on either February 18th or February 20th, please.
Fantastic accent.
20th's no good. 18th we can offer.
Fantastic
May I
accent.
inquire how many the court has set on the 18th? Counsel, do you have any other dates available within 35? Later dates?
I believe Mr. Reed can accept the 27th. I do have some concerns about going out that far and not being back in front of the court sooner as needed.
The people will accept the 18th of February.
All right, February 18th, 1:30 p.m. for preliminary hearing.
Can you say that was Mr. Reed?
Yes.
Thank you.
So they can say the R at the beginning of a word. He said Mr. Reed, but he can't say the R at the end of a word. I don't want to go out that far. Why don't they put the R's at the end of the word? Anyway, it was fantastic. Little accent there. Let's do this one. And a banana. Okay. So we've been to Indiana with a judge you can only see here. We've been to twice Colorado with 2 judges you can only see here. And now we're going to Georgia. And yes, you can see Georgia courts in other YouTube channels, but not this judge and not this court. You can only see him here. So this guy on the left was the old business owner. And the guy almost sitting down, bending over right now, he used to be the former employee. Okay? I got him switched in my head when I first watched it, but now you guys know. And I think this is Northern Georgia, though. Eileen will let me know, because the accents are not as thick. We're not going to get fantastic Georgia accents right now, which stinks. It's Dawson, D-A-W-S-O-N, Dawson. I can't say that word, but that's where it is. I feel it's up north because of the accents.
Right. All right, so if I remember right, it's been a while since I've read this file, but if I remember right, Mr. Gallagher, you owned a company at one point in time, correct?
Yes.
We've seen this judge a couple times before get mad. And it's so adorable when he gets mad. To me, there's no other way to describe it. He's adorable when he gets mad and starts yelling. Normally, though, it's at women. It's at a mother to her daughter. He gets really mad when moms sue their kids. So, he's about to get really mad and yell at one of these two. And just so you know, it's adorable.
And Mr. Hortes, you were employed by Mr. Gallagher's company,
yes, sir.
Correct? Okay, perfect. At some point in time, there was a separation of employment between you and the company.
Yes, sir.
And you then sued for $702.09 in what amounted to a last paycheck.
Yes.
Okay, perfect. All right. That was filed in June of 2025. And then service was perfected July 14th, 2025. And then, Mr. Gallagher, you failed to answer that particular service for.
See, did you hear him? He said July. All my other Georgia judges say July, but he just said July, which really hurt my feelings a lot.
The lawsuit, correct?
I never received service.
You never received service. Who is Terry Gallagher?
My wife.
Okay.
We live in a gated community, or
Okay.
we did then, and they couldn't get in past the gate. So it was I think what it was, she was leaving the subdivision where we lived, and a police officer just happened to be there and gave it to her. So I knew nothing about this.
Okay, so but she never gave it to you, is
No.
what you're saying. Okay, gotcha. All right. Let's see. When did your employment end? Do you remember?
July 2022.
22? Does that sound right?
I believe so.
And it's your allegation that you sold the business in 21?
Well, I'm not sure if it was 21 or 22, but
Somewhere around there.
if he says 22, then it was 22.
Okay.
I sold the business approximately 4 to 6 months after he was no longer employed with the company.
Okay, gotcha. All right. So after all of that was said and done, sometime in September of 2025, September 29th, 2025, a default judgment was issued for failure to respond to the lawsuit in favor of Mr. Fortis.
For the record, if I write you a check and I hand it to you, and you wait even 3 days, there won't be any money in there. This guy got a paycheck, waited what, 3 years? I don't know if it was that long. It was a significant amount of time. He waited that long. The business had shut down by that point. Then he tried to cash the check for $702. I promise you, if I write you a check, if you don't go directly to your bank, that's your fault.
I then received the email from you, Mr. Gallagher, kind of alleging all of these inconsistencies and everything else, and kind of trying to figure out where we are. So that's kind of where we are today, okay? So I guess the biggest thing is, Mr. Gallagher, what are you seeking today?
The company paid him his last paycheck right after he left. It was paid every 2 weeks. The next pay period after he left, he received the check. Whatever year it was, 21 or 22, I'm not even sure what year it was.
Whatever year it was, okay.
If it was 22, then that's what it was. So the check was issued to him. He actually called me over the summer. This is how I figured this out. He called me over the summer and said that I owed him money, that he had just gone last year, 2025, to the bank with the check for the first time to deposit it. So 3 years after the check was written, he tried to deposit the check. I had already sold the company. The account was closed. I don't feel that I owe anything, and he should show the check with the date on it, showing you that he was actually paid, but he failed to cash the check. I don't feel that I have responsibility after I've sold it 3 years later.
I agree. I agree with that. I have no idea what the law is on that issue, but we're not going to find out because that's not the issue here. The issue is not him and his check and when he cashed it, blah, blah, blah. That trial already happened. He already got the default judgment for that.
Gotcha, okay. Did you receive a check at any point in time?
Check's here, sir.
You had the check, perfect. Okay. Northside Tree Professionals. Looks like account ending in 1375.
Could be.
And it looks like there's at least a G that I can tell here. And a J. So I'm going to assume that it's your signature. I'll get confirmation later. So it is for 702 and 9. Did you attempt to deposit this?
No, sir. I found a check. The check got mixed in the mail that I had in the car. When I went to sell the car, I cleaned the car out.
And you found the check?
And I found the check.
Okay.
At which point I went to the bank, didn't try to deposit it like he states. I spoke to the lady, to the clerk. She said, I cannot cash it because it's been over 180 days. The check is no good by itself.
Right.
You need to get it reissued so we can go ahead and process it. At which point I called him June 2024, June 11th, 2024, and I have proof of that call right here in this device.
Okay.
And I told him, John, look, this is where I'm at. I got this check, and you write me another check. No, I sold the company. I have nothing to do with that. You go talk to the new owner.
Okay.
I did. They said, no, that's his. He was the one in the company, owning the company when he issued the check. He's responsible for the check. So I went to DeKalb County, trying to file in DeKalb County, and they had me go to the Secretary of State webpage and look him up. In the Secretary of State webpage, he appears as the agent, registered agent for that company for until September 2023. and I have proof of that here too.
Okay.
So he's totally responsible. I mean, he could have, if he wanted to handle it diligently, he would have said, okay, I'm gonna take care of you, but I'm gonna have to charge you a reissue fee or something like that. Even if it was money, I would have took that back then. But I had to do all this run around, you know, doing my due diligence, and come to find out, he comes and said he sold the company in 21. I mean,
I gotcha. Okay.
he was made aware of it before the 2 years was up on the check.
Okay.
And he kind of brushed it up under the rug. Said, no, I'm not responsible for that. Go talk to the new owner.
Okay. So you, when did you contact him about reissuing the check? What was the date?
6/11/24.
6/11. June 11, 2024.
24. When I spoke to him in 25 was because I already filed. I was already filing. I was trying to give him a chance to pay up. You know. And actually, we did have an agreement over the phone, a verbal agreement, which I have proof of as well. He said, hey, I'm gonna take care of you, don't worry about it, I just need you to go and call this thing off. But he never pays. Why am I gonna call it off if he never pays?
Okay. All right. If you will give that check back to him, please.
I just work for that money. I think I deserve to get paid for it.
I understand.
The lady at the bank told me that bank, when I went, she said that bank account's still open and it's got enough funds in it. I said, enough to cover this check. She said, yes.
Okay.
That's what I told him. Obviously, he misunderstood what I was trying to tell him.
Gotcha. Okay. Of course, this is gonna take forever.
The judge is muttering under his breath. Of course this is going to take forever. We haven't gotten to the reason why we're here yet, guys. Everything the judge just talked about means nothing to why we are here today. Here we go. While he's pondering, this is a different courtroom for him. We usually see him in the other courtroom, in case you were wondering.
All right. So basically, you're looking for the judgment that has been issued to be set aside, correct?
Correct.
Okay. All right. Obviously, you would be opposing that particular issue.
I'm sorry.
No, you're good.
No, I'm sorry.
So, there are 3 reasons under which a judgment can be set aside under Georgia law. One is lack of jurisdiction over the person, meaning that you were improperly served, or I don't have jurisdiction over the case itself. You do reside in Dawson County, correct?
Yes.
So I have jurisdiction over the case. And based upon the evidence of service that I have, a Terry Gallagher was notoriously served, was personally served, notoriously serving you, okay? The second option is fraud, accident, or mistake, or acts of the adverse party, meaning Mr. Hortus, that are unmixed with any negligence or fault of you as the moving party, okay? We'll come back to that one in a second because that's where this one lies. The last one is a non-amendable defect which appears upon the face of the record of the pleadings. That's not in this particular case at all. There's no issues with the case file itself, okay?
I didn't understand a word he just said for the third one. It didn't sound like English.
So the issue becomes whether or not Mr. Hortus has obtained this judgment by any sort of fraud, accident, or mistake, or any sort of act that is unmixed with any negligence or fault on the part of yourself, Mr. Gallagher. I see this a lot. This happens all the time. Not to this extent, but I get a lot of these requests for to set aside judgments. Based upon the evidence that I have in front of me, and with the time that the case has gone on, the motion to set aside is denied. I cannot say that there was any acts of fraud or accident or mistake on the part of Mr. Hortus in seeking the judgment, and I cannot say that there was not any negligence or fault on your own. Unfortunately, under Georgia law, we're very strict when it comes to service, and it's very presumptive strict. If you are notoriously served by the sheriff's office to somebody else that's supposed to live in your household, then we assume under Georgia law that that person is going to tell you about the lawsuit. So unfortunately, at this particular time, the motion to dismiss or the motion to set aside is denied, okay? That does mean that there is still a judgment for $702.09 plus the 110 court costs against you. That is still up to Mr. Hortus to try to collect on, okay? He has ways that he can try to seek collection, or you can pay it and be done. You know, but that's outside of the court, okay? That the case is to be outside, okay? Yes, sir.
I mean, that's really what I'm looking for. I'm looking to, get it done and close it and move on.
I understand. So because it's just since it's a judgment, I no longer have any additional jurisdiction over the case to compel either one of you to either pay or anything at this point. So you two can come to an agreement yourselves to pay and work it out. Or if you don't, that's fine. Then Mr. Hortus, what you can do is you can go back over to the office for magistrate court and you can get some information about how to go about collecting.
Yeah, I have.
Okay. Mm-hmm. So then those are the options that you have to be able to go through if Mr. Gallagher is not willing to work with you, okay? All right. Any questions?
Yeah, how long does somebody have to be able to cash a check? Indefinitely? Because that's what this appears to be.
So, sir, unfortunately, that's not the issue. I'm going to be completely honest with you. And I've tried to dance around this as much as possible. And I've been nice to a whole lot of people in this courtroom. You were served with lawful service of process in July of 2025. A default judgment was issued against you in September of 2025. I received an email to my office dated January 9th, 2026. The law gives you 30 days to respond to a lawsuit, and you took 6 months. I understand that what your argument is you didn't receive it. That's between you and your wife, unfortunately. That's just a part of the two of you having to figure out how you communicate with each other. But as far as the law is concerned, you were properly served and you failed to answer the case. It has no issue as to whether or not Mr. Hortus could have proven his case or not. I'm not making the determination about that. That's completely outside of the issue. You had a chance within 30 days of being served to contest and bring up any sort of issues that may have been defensible, and you failed to do so. There's no fault, accident, or neglect or mistake on the part of Mr. Hortus that is unmixed with negligence or fault of your own self for not answering the lawsuit. Period. That's it.
I'll work with him, so that's not an issue. However, I did make a phone call to the court, and the lady told me that they were dismissed. There was an order where they were going to dismiss the case. I was told this, that's why I wrote it down. And so I assumed that the case was being dismissed. Then I got this notification in whenever it was, September, like you said. That's when I called. And I
when was that call?
After I got that notification in September, I called and I said, I thought you were dismissing the case. And they said, yeah, we're not going to deal with this anymore. Those were pretty much the words that I was told over the phone. We're not going to deal with this anymore.
Okay. So when was your...
I'll take care of them. You know,
well, no. I mean, you're obviously alleging something that's really troubling to the court because you're calling out my staff. So, I mean, I would really like to know when you originally called and were told that the case was going to be dismissed.
Well, they said they were going to put in an order to dismiss the case. That's why I wrote it down. And it was, I guess it was in, I don't have all the dates, but I would assume this was back in the fall.
Okay. So here's the...
I couldn't give you an exact.
So here's the thing, and here's the question that I'm going to ask, and I'm going to ask it very, very bluntly. You received service. Your wife gave you service. You just told me that your wife gave you service. So you lied in a courtroom in front of a judge, and I could hold you in contempt for perjury and have you prosecuted for perjury because you received service and you decided that you were not going to answer the case. And then you call my office trying to figure stuff out before September, because if you're saying there's an order to dismiss that's being drafted and put in, it was before September. And then you get the notice after September that a default judgment has been issued and you're upset. So you call back and are told that we're just not going to deal with it. What I'm going to tell you right now, Mr. Gallagher, is before I get any madder, I suggest you shut your mouth, you pay him the $702, and you get out of my courtroom. Because otherwise, you're going to go through the special door. And you don't want to go through that door. I can promise you that. You're dismissed.
Hey, let's get together. Later, outside.
Am I good to go?
You're good to go.
Okay.
I told you he was adorable. I told you, was that not the most adorable Judge Meltdown ever? I love when he gets mad. He's so adorable. Wait. I don't remember. Hold on. We did that. Perjury. All right, we got one more. I got one more for you. This is lots of dead air. This is just waiting, but that's the point. So this guy didn't show up for court. Watch what the judge does. It's so cute. This is really quick. This isn't a long one. Holly, thank you so much. Thank you. This is
You have a phone number on there for him?
Indiana. This is Judge.
All
I
right.
can't read that. I don't know.
You shouldn't have said the 26th because he's probably still in. Oh, January 26th at 1 o'clock. Is that what it shows?
You can only see this judge here. He's about to do something very Judge Middleton.
You got, the board has 3 things. You've got 2 change of name and the other that's set within truck. Here's the other. Everyone's got something that's got.
Shows Vandalia Road. Postage bond.
Please have that.
Yes, it's Judge Riggins. You're 100% correct.
This guy lives in St. Paul. The guy posted his bond.
Okay, I had a cup of coffee. We can start our stream now.
Please leave your message for 7.
He called him. He didn't show up for court, so he called him. He's not done yet. Oh no, Fee, you missed it. It's not the verdict that was the great, well, it was the judge meltdown. You should rewind because it was really good. It was so good.
Hi, this is Judge Riggins. Is this Anthony?
Yes.
Hey, Anthony, you posted Curtis's bond for him, and he did not appear in court. Do you have any idea where he is at?
Yes. They didn't post because of the winter storm, like on the website and stuff.
Right. So do you have a phone number for Curtis or something? Because there's not one on here. Does he have a phone?
Yeah. Give me a second.
Yeah, sure.
And you gotta get that. So, yeah, 1 second. Let me pull it up.
Is that your father-in-law? I take it. I heard you say your dad. So is Curtis your father-in-law? Okay.
Your dad's cell phone number.
Monica, are you in pain?
It's about the court thing. Oh.
Hi, this is Curtis's daughter. What is this about?
This is Judge Riggins. Your dad's supposed to be in court today, and he's not here. So I'd rather just call him and tell him to get here, rather than send a warrant for him. So, but
Okay, sir. Yeah, he told me he had spoken with somebody yesterday, and she was supposed to call his phone. So
Yeah.
I'm not sure what happened.
yeah, give me a phone number if you would, please. What's your name?
Okay. My name's Amy Spangler. I'm
Okay.
his daughter.
Okay. All right, Amy. Thank you. Yeah, please.
Yeah, I'll give you his phone number, and I can reach out as well, like immediately.
Yeah, that's fine. Yeah.
Okay. 1 second. It's 317-798-92.
Sorry about that. Oh, I missed that.
Call, and then if he doesn't answer me, you might follow up with him and say he needs to contact the court. But I'm gonna call him right now. So okay.
Okay. He actually works in Shelbyville, so I'm sure he can just leave work and be there like as soon as possible.
Well, that's all right. Where does he work?
It's Old Hickory, like
Yep.
where they build the cabinets and
Yeah,
all that.
I can look out the window and pretty much see the building. So, yep.
Okay. Well, I appreciate you giving a call.
Okay.
Thank you so much.
Thank you, Amy. All right.
Okay, bye.
See you. Bye-bye.
This judge is really good at muting out all personal information, like all of it. So I didn't even think to make sure. Monica, are people helping you? Do you have people around you to help you?
Call has been forwarded to an automated.
So it's approximately 1 o'clock right now. The hearing he was supposed to be at was for 1 p.m. and he just started calling. So, you know, it's probably like 10 after 1 or whatever. Their time in Indiana while we're watching this.
Curtis? Curtis, this is Judge Riggins.
Yes, sir.
Hey, you were supposed to be in my court today. You're not here, but
No.
so let's just stop talking and listen up. I want you to be here at 1:30 today. Can you walk over? I know you work at Old Hickory there. Can you walk over and be here by 1:30?
Absolutely, sir.
All right, we'll do that. I'll see you at 1:30. You come on over at 1:30. We'll knock out your initial hearing, okay?
Okay, sir. Thank you so much.
You're welcome. All right, see you.
Absolutely, sir. I'll be right over. I would too. He left. He came over. He complied. It's boring. I didn't get the hearing. We don't need to see it. It's just initial appearance. But that was pretty cool that he called his son-in-law, his daughter, and to get to him. And he's right across the street. I wouldn't have been surprised if the judge would have said, prosecutor, defense attorney, bailiff, come with me. He walks across the street to the guy's job. It just reminded me of Middleton, you know? Special judge. Anyway, guys, thanks for coming out. I really appreciate it. I really do. Tomorrow is Saturday. I'm going to set up OJ now. Just so you know, you missed it yesterday. Yesterday, Johnny did If the Glove Don't Fit, You Must Acquit during his closing. Twice. I'm sorry. He said, if it don't fit, you must acquit. I did not hear him say once, if the glove don't fit, you must acquit. So if he actually does say that, unless that's the Berenstein effect, then he hasn't got to that point yet. But he did say twice, if it don't fit, you must acquit. Monica, try to relax. Don't do too much. Don't overdo yourself. All right? Yeah, guys, stay warm. Have a great day. See you in OJ, or I'll see you tomorrow morning. Or I'll see you in American Courts tonight when he streams. No, just kidding. Bill, do a live stream with me, Bill. All right. I'm going to set up OJ. See you soon, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my a joy she can't hide.